So it's 7 o'clock, so we'll start the hearing. So I'll start by reading the notice, and then we'll go. So, in accordance with Mass General Laws, Chapter 48, Section 11, notice is hereby given that the Bolton Zoning Board of Appeals will hold a public hearing on Tuesday, May 7th, 2019 at 7 p.m. in Town Hall, Board of Selectmen's Room, 663 Main Street, Bolton, Mass. To act upon an amended decision regarding the building inspector's zoning determination of Celtic Counseling LLC, 401 Main Street, Bolton, Mass. Identified on Assessors Map 4D as parcel 20 for counseling use and permanent living. So, a little background to talk about, and then we'll lead up to public comment. So before the board this evening is a proposed amended decision in the Celtic Counseling matter in 401 Main Street. By way of background, this matter originally came before the board as a result of a building permit issued by the building inspector in November 2016 for a temporary modular building for agricultural use at 401 Main Street property. On November 28, 2016, several residents filed an administrative appeal with the ZBA, appealing the town's building inspector's issuance of the building permit and alleging that Celtic Counseling's use of the property for counseling services was prohibited and not protected as an agricultural use under Mass General Law, Chapter 48, Section 3, which is commonly referred to as the Dover Amendment. So on October 24, 2017, after a series of hearings, the board issued 3 decisions, that board being the zoning board. In the first, the board reversed the building inspector's zoning determination regarding 401 Main Street counseling use, finding that the agriculture exemption under the Dover Amendment does not apply to Celtic Counseling's business. In the second decision, the ZBA reversed the building inspector's zoning determination regarding 401 Main Street's congregate living aspect. And in the third decision, the ZBA upheld the issuance of the building permit for a temporary modular building. On May 9, 2017, Celtic Counseling Center LLC, Edwin Madera, Deborah Madera, and Andrew Lappin filed a verified complaint against the board in Massachusetts Land Court appealing the counseling use decision in the congregate living decision. They alleged, among other things, that the use of the property was protected under the Dover Amendment as an agricultural use. In addition, on May 25th, 2017, Deborah Madera filed a charge of determination against the ZBA with the Massachusetts Commission Against Discrimination, MCAD, alleging that the ZBA's decision was motivated by gender and disability discrimination. The ZBA filed a motion to dismiss with MCAD, which is pending. During land court litigation, town council and council for Celtic Counseling discussed a potential resolution of the litigation in the MCAD charge. After extensive negotiations, a settlement agreement was reached and approved by the ZBA and the Law Committee on March 6th and March 7th, respectively. The settlement agreement includes terms for an amended decision addressing the use of 401 Main Street, as well as a release of all claims against ZBA and the town. So rather than unilaterally conclude the settlement agreement without the benefit of public hearing or public input, the ZBA and the Law Committee decided to memorialize the terms of the agreement in an amended decision. The purpose of this hearing is to review the terms of the amended decision, review Celtic Counseling's proposed site plan, obtain public input, and discuss with Celtic Counseling whether any potential revisions to the amended decision are agreed upon. Copies of the settlement agreement and amended decision are available for your review this evening. If you'd like to review a copy, please see Erica. So, in the document, you'll see, or I'll explain, there were 9 key items which are set forth on pages 5 and 6 of the amended decision. And the 9 items are as follows. First, Celtic Counseling's use and operation at the premises at 401 Main Street will be limited to farming and agriculture, providing outpatient counseling services using farming animals and licensed therapists in the delivery of counseling services, and uses otherwise permitted in the residential zoning district. all other uses are prohibited. Secondly, cultivate counseling will have no more than 14 total employees on the premises at any time, including owners or partners of cultivate counseling and resident workers. Third, hours of operations are limited to 8 a.m. to 7 p.m. on Monday, Tuesday, Wednesday, and Friday, 8 to 8 p.m. on Thursdays, and 9 a.m. to 3 p.m. on Saturdays. In addition to the maximum 14 total employees as set forth, and except for special events which will be described in the sixth bullet that I'll describe in a moment, no more than 25 people will be permitted on the premises at any time. The fifth item is cultivate counseling will provide on-site parking sufficient for 20 vehicles and in accordance with the dimensional requirements of section 250-17C, section 11 of zoning bylaw, and that's set forth in the site plan that the applicant has provided to us. I think they'll have a large-scale one, but we have miniature ones in our plans. Okay, and then paved on-site parking is not required. The cultivate counseling will operate in accordance with the site plan as approved by the ZBA, and any amendments or changes to that plan must be approved by the ZBA. The sixth item is regarding special events. So special events shall be limited to no more than 50 people in attendance. They shall be ticketed, with only those holding a printed or electronic ticket allowed on the premises, and shall be approved in advance by the Chief of Police and Board of Selectmen. There should be no more than 12 special events permitted in any calendar year. If a police detail and or off-site parking and shuttle service is necessary, in the discretion of the Chief of Police or the Board of Selectmen, cultivate counseling will provide the same. Cultivate counseling will pay the town the normal customary charge for any police detail. 7, any signage at the property will be permitted only in accordance with section 250-18E of the zoning bylaw and upon written permission by the Board of Selectmen. 8 deals with fencing. Any new fencing at the premises that is visible from the roadway shall be professionally installed and of a design and material subject to the approval of the zoning board of appeals. All fencing shall otherwise conform with the requirements of the zoning bylaws. And 9th, the amended decision shall apply only to cultivate counseling and shall not run with the land or be transferable to any other organization, entity, or owner. So those are the 9 key components of the settlement agreement, and at this time I'd invite board members and then cultivate counseling and then the public to comment. So board comment on what we just went through. The disagreement, agreement, I think those that were involved with the process, this is consistent with what was decided. Negotiated. I'd like to, from my perspective, I wanted to at least highlight that some of the key components was, one, with the decision or the settlement, we wanted to, as well as the selectmen, make sure we hold the public hearing, so that it's open disclosure and and highlight, the throughout the process, the abutters had concerns, and that we try to alleviate some of those concerns by involving the selectmen and involving the police in the decision for any events that would require larger scale than the normal operation. So
I feel like these points addresses the question of how many people will be on the premises, the number of cars, the parking, the situation, the potential for blocking rights of way, things of that nature, as well as the hours of operation.
And a lot of those points were brought up as concerns, I recall during the hearing of people who were concerned with, overflow onto streets, safety onto the side road, things like that, hours of operation. So as you say, it's trying to put some fairly decent parameters around the operations so that it's beneficial to the applicant, the property owner, as well as the neighbors.
This is not precedence for somebody.
I had some concerns initially that special events had not been really well defined in the document. However, I was later given some assurance that since this had to go through the Board of Selectmen, each event had to go through the Board of Selectmen, there would be additional scrutiny at that time regarding the special event that was requested. So I feel comfortable with that now.
And I believe the Board of Selectmen on board with knowing that, they're a line of defense, should something come up like that, that the matter will go to them, and they're aware that, this is part of this process that we're agreeing to. It's part of the board, but also, as part of the agreement to sort of settle the differences and avoid court and whatnot.
Yeah, I also had a concern at the time that we were setting a precedent in the town, and this agreement basically says this is a one-time only, does not carry on with the property if it's sold, so that this application basically allows them to operate under some of the conditions they wanted, not all.
Mhm.
And that the town is not admitting to the Bilber Amendment as a reason for, the use of the property.
Any other board comments? Because we'll open it up to corporate counseling's comments, but I'd also like to just do a walkthrough of the site plan. I think with a larger scale that, better to read through, and if people have any questions or comments.
I did have a question about the fencing aspect. Has all of the temporary fencing been removed from the property at this point?
All the visible fencing from the road has been moved.
Which was our request at our mediation.
So that from this point on, any fencing that will be added will be subject to the...
We did that prior to the signing of the agreement. It was requested that we do that. Our position was that it didn't violate any of your building laws, it just wasn't sightly.
Okay,
So,
thank you.
so this is the site plan. What we were asked to do.
Just for the audience and also for public, just introduce yourself.
Sure.
So-
My name is Rob Ansel. I'm an attorney in Westford. I have represented Cultivate Counseling since the start. We're going to do a brief introduction. The town of Bolton has a home occupation bylaw, and when we had gone through the zoning board of appeals process, the town of Bolton's home occupation bylaw is a relatively liberal bylaw that allows for a great deal of different uses. It certainly was designed for the lawyer, doctor, engineer kind of person that worked out of their house, but it does allow for quite a number of employees. When we went through the zoning process, there was a considerable amount of discussion as to whether or not the Dover Amendment, which says that if you are an agriculturally based business, that you have tremendous amount of leeway as to what you want to do. We are a little bit bigger than your home occupation, not much. We actually could have worked around that. We also could have said that our farm employees and we could have set up two sets of books. The home occupation would be the counseling business and the farming could be farming. We didn't want to do that. We wanted to be good partners with the town. We wanted to be fully transparent. We had a number of court hearings and a number of settlement discussions, including an entire day off-site day with Brad Reed and Kay Stoner and your town's attorney, David McKay. That's where the framework for our 9 conditions came up. What the board wanted to do is bring some semblance to where we were going to be parking. As you enter into the property from Barnum Road, which is our main means of access, there's a whole bunch of different places where one could park. What the board asked us to do is designate 20 parking spaces, which would be compliant with your parking bylaws. So that's what we did within our current space. We hired a surveyor whose name is Stan Dillis, who's a surveyor in town, has done a considerable amount of work in the community to come up with a plan. The board said, kind of as a proof and so that we knew where cars were, can you come up with 20 parking spots? So we came up with 20 parking spots, and which complies with our hours of operation. We are not going to be required to put down pavement in that area, nor are we going to be required to actually label the spaces, but it was more of a proof thing to show that at our maximum occupancy between people that we service and our employees, that we're going to have space for them. So that's what this site plan is. We don't have a designated one-way, but that's our general flow of traffic. There was some complaints about our fencing, which was along Main Street. We eliminated that fencing, and we've generally tried to do a good job keeping up the property. We have reached an agreement with the town relative to what those 9 points are. In the past, we had reached out to a number of people in the community and said, if there's anything particular that you would like, one of the things that was recurring is the fence, then we would try to address that. We're certainly not signing up to spend a considerable amount of money, but we do want to be good neighbors. And we're welcome to that input. So that's kind of where we are as an overview. Our position is that, or was and has been, is the Dover Amendment gives us exemptions, and even if it didn't give us an exemption, we would have been able to work around that, but we've wanted to be as transparent in embracing of the community as we possibly could be. So instead of pursuing the MCAD claims and our land court claims relative to saying that we have the right to farm, and if we had the right to farm, and just by way of background, and the court determined that we had exemptions under the Dover Amendment. The Dover Amendment allows you to, it's kind of an all or nothing thing, that if you're deemed to be farming, then there's no ability for the municipality to regulate. If we have lost that claim, then we'll be back to saying that we have farming employees over here and home occupation employees over there. We didn't want to do that. We wanted to run as an inclusive of business as we could. So certainly willing to address any questions that you might have relative to the process or the site plan or where we are.
So on the site plan, Erica, you indicated that the size of the spaces are complying with
Yeah,
local regulations?
correct.
And that's okay.
And this is just really to depict
So
where
could you, identify yourself?
Oh,
please?
Judy Leonard, 42 Burnham Road.
Okay.
So this plan is really just to depict where the parking
Correct.
lot is, right?
Mhm.
Nothing else is,
No, we were concerned during, we were concerned for public safety issues that were raised about on Burnham Road parking or on Main Street.
Yeah.
And so, and then with the idea of if they're gonna limit the usage or the number of people on the property, how are you gonna keep the cars on the site. So
Mhm.
this is, you know, as they said, it's not making them put in parking numbers or but they're able to prove to the town that with the required space size, they can accommodate those 20 spots.
And they don't have to be lined or anything, it's just
No,
that,
it's just the
math.
building.
There was a question as to when we were going through this process that I had told Mr. Reed and Ms. Donner that repeatedly that this area is wide open. We have plenty of space to park, and both of them said, Rob, can you just show us? That's an important thing for us to do, that we want to go through the site plan approval process, although not required under this process. We want to make sure that we have safe vehicular access and we don't issue where people are parking. And if you're going to tell me that your maximum amount of people on site is going to be 20, I want to show you that you have 20 spots. Now, depending upon the time of the year, I know that we have various wetland issues and those spaces end up changing, but we certainly have the availability to
that
park
was
20
one of
cars.
I was gonna
We actually have
ask, so
crushed
thank you.
stone.
We have crushed stone, and we also have some sawdust and some bark mulch and other things that dry up that space. Our goal is to make sure that we're always going to be fire accessible and to keep an open lane through that. It's a rare day when we have 20 cars at a particular time.
Do you have to have any hay bales or anything?
No.
Okay, and,
So we're not, you know, where we are, our permitting relative to parking doesn't require us to, you know, keep a distance from wetlands or keep an area that's dry, or, you know, that we have to prove that we could pave that or anything along those lines.
okay, my next question is, what about trucks or vehicles, farm vehicles? Is that, how does that work with your parking spaces?
We don't have any.
We don't have any
And you won't have-
equipment or, no.
And no trucks, you have no, what about horse trailers or anything like that, nothing?
We don't event or show, so they don't go anywhere.
And if we did, it's a one-time thing. It's,
Okay, they
this
won't be
is,
packed on
this,
property.
no, this is essentially
Okay.
a safety plan.
All right.
That's what the plan was designed for.
This property remains.
Could you
oh,
identify
excuse
yourself?
me, Nancy Skinner,
Nancy Skin, okay?
still remains as residential.
Yes.
So does that require somebody to be living there 24/7? Because I very rarely see any lights in the house to tell anybody
Yeah,
that
there's-
If
it's.
someone lives there.
724, absolutely.
Does the owner live there, Madeira?
You just asked if someone lived there, someone lives there. And again, I don't know what the scope of that is in this discussion.
No.
Somebody is definitely there, 724, have to be for the animals or home.
Well, I see the young man walking his dog on the Burnham Road, so I know he's around there sometimes, but I don't.
The decision
very
doesn't
often.
require us to be owner occupied. What it does is it pertains to this ownership group and the entity that manages the farm, which is Cultivate Counseling.
And that's okay with residential property? What
That-
they've decided?
Yes.
That's, okay.
That's what the nature of the lawsuit is.
Okay.
Linda Austin, Burnham Road. With regard to the special events, it says no more than 50 people in attendance. Does that include the people who are working the events, or is that just people attending the events?
It was our intent that we were gonna have 50 people maximum on an event. We haven't had events like we've had. We wanted to reserve our right to have events, but it's not been a big part of our current plans.
So that does include the employees?
Correct.
Yeah.
Would the events be on holidays or
What we
or
wanted
during
to
those
do,
work hours that are
but
specified?
there are going to be during those hours, they
The specified, okay.
They certainly may be, you know, I envision that we're, by the nature of fall in New England, that the a Columbus Day thing, so you asked if there are gonna be holidays, Labor Day event, kind of around the fall harvest kind of seasons.
Rob, just to clarify too, you said the word wetland in the parking area. Do you mean an area that just doesn't drain well? It's
It
not
doesn't drain
literally-
well.
Okay, it's
It's
not
not a-
literally a wetland.
No.
Okay.
What I meant to say is that our parking did not have to comply with wetland regulations, just asked us to put lines on a plan that showed. That area remains wet, where we're parking, we've done a lot to dry that out. It's not a vernal pool, it's just an area that poorly drains. I think that
And it's not a potential vernal pool?
no, and I think that there's very high bedrock in that area, it just doesn't drain particularly well.
Yeah. They've delineated the 100-foot buffer zone, which is all the
Oh, that's right.
waterways out of there, so.
Right, yeah, the plan shows that you're not in any buffer or riverfront areas,
Right.
that's good.
And the hours of operation do not say anything about Sundays, so the only thing that's happening Sundays is agricultural, taking care of animals.
So, just someone feeding animals.
That's all.
Again, we really want to work with the community. We've wanted to do that from day one. We got off to an interesting start, but we've been good to the community since then. They've done a lot of outreach through counseling with the neighboring schools, and they plan to continue to do that.
Okay. Any other comments from the audience? Nothing from the board. Okay. Okay, so I guess at this point, do we have a motion to close the public hearing?
Can I ask one more?
Okay, right,
Wait,
slip it right in there.
Okay, good. The fencing, it says all fencing shall otherwise conform with the requirements of the zoning bylaw and subject to the zoning board approval. Okay, so, I mean, Board of Appeal. So what exactly kind of fencing would be approvable?
You look at the bylaw, you see the
Oh,
fencing bylaw.
And there's this, I don't remember what it is off the top of my head. Your zoning bylaws specifically tell you what you can have for fencing. What the complaints when we had opened up was that we had put some fencing along Main Street that was objectionable by right where the house was. The fencing provision was designed to address that. We're a very, very small not-for-profit that has an exceedingly limited budget, and the request was to have new fencing. Originally what the board had said is, can you do something with nice fencing around your entire property? And the board's response was, the Cultivate's response was, we could commit to that in 6 years or something along those lines based upon what their cash flow projections were. So what we had said is, look, we will address the fencing at the front of the property, and anything that we put up, we will make sure that complies with your fence bylaw. So, and fence bylaws vary. I oftentimes will say that if a fence is greater than 8 feet in height, it becomes a structure, and you have to be off of the property line to do that. Whatever fencing we have now is what we intend to keep, with the exception of certain maintenance requirements that may end up coming up. So
the fencing you had was
it's been
valid,
replaced, and we're
right?
not going back to that.
Okay, so what is your fencing that you have now? that You're
That's
gonna
our
be
fenced
using?
area now.
Well, we
What?
took away that fencing that was by the house, that was a big concern everybody had, so we actually removed that. And the
Okay.
fencing in the back is what, metal and,
Yeah, it's metal, some chain link, some horse panels, just depends what's big there.
Okay, I was,
it's not visible from the
all
road.
right, I didn't know whether or not you were gonna re-fence.
Not where that fencing was.
Okay, all right, good, thanks,
That's it.
that's it.
Anyone else the last? All right.
Oh, no.
I would make a motion to close the hearing.
Second.
Okay, second with Brad, so all in favor, Motion to close the public hearing, aye?
Aye.
Okay. So, so at this point, having gone through the history and conditions, I ask that we consider whether to approve the amended decision. So there was a motion to approve the amended decision.
I would make the motion that we approve the decision.
Amended decision, okay.
Second?
Second by Kay, all right, perfect. So all in favor of approving the amended decision, say aye.
Aye.
Okay, perfect. And then,
State that was unanimous, I think, since we only have one
yeah,
member.
okay, so both those motions were unanimous, passed. And then, with regard to the last item with the decision, so we have to finish the writing and the filing of that amended decision, so at this point, I'd like to entertain, is there a motion to authorize myself as chair to finalize and file the amended decision consistent with the board's deliberation and votes and in consultation with Erica, our town planner, and town council?
I would make I would make a motion to approve that plan for you and Erica to work out
The town council.
with town council.
Second.
Okay, second by Andy, so all in favor of that motion, say aye.
Aye.
Okay, so that motion passes unanimous as well.
So Gerard,
Mhm.
on the record of vote, Brian Holmes' name is on here.
Mhm.
We're just gonna mark that he's used as absent, that doesn't affect the outcome.
Correct. Because we still had a full
Yep.
quorum majority, so. Mhm. We went through that earlier, so it's fine.
Thank you, guys. Thank you for giving up your entire beautiful summer day. Mediate our case.
Yes.
I was on the zoning board of appeals for years in there, and I never had to give up an entire day, so thank you.
Thank you.
Yep.
You don't have to wait till 8 o'clock for the next business,
Actually, I was just gonna ask you, do you need them?
We should keep one.
We should keep one.
I was not very. I was out there the day you showed me the village.
Oh, boy.
Yeah, once we reported with the.
Because he came back in the house.
And then we did 20 days. Others are going to be here. And then once you get the staff.
The bottom.
Yeah.
We'll be up for next week, because a lot of it is all put together.
I'd be surprised if it takes us more than a week.
So once it's filed in 20 days after that, you'll keep us informed of the timing of that. Or somebody will.
We'll let you know, I'll let your council know when it gets filed.
Okay.
With the town clerk, and then you'll know from there.
Thank you very much.
Okay.
Appreciate it. All right, thanks.
Thank you.
Thanks, Bob, one question. When did you end last night? I missed the meeting.
I was home before 10.
Is that right?
Yeah.
Yeah, I missed you speaking.
Well, you don't need to hear me.
Yeah, no, it was, you know, it was 35 or 37 articles or something like that. We just went right through it. It was pretty good. So,
Enjoy
all
your
right,
evening.
thank you.
Thank you for coming.
Well, thank you for getting this wound up.
Yeah.
That's only 2.5 years.
This next matter is from 2013, so.
I'm leaving now.
He doesn't need to be present, I
No.
asked him to be
Yeah.
present, and he never responded, so I
I
honestly
think
have no
this,
idea
all
what's
right,
coming.
good night.
Yeah, so
So,
let's
let's just get started.
proceed. Because
Yeah.
at the end of the day, if we say we leave release the bond to the, and he's gonna be happy if he comes in and says it's already taken care of, so.
Yeah.
So, release the hounds, right? So,
So in your
there, you
packet-
did some homework around this.
I did.
the,
So in your packet is a copy of the coster, and I tried to highlight some of the important numbers for you.
Mhm.
And then in addition to that, I provided a memorandum based on a conversation that I had with Mass Housing, to go through the cost certification. We've moved on to the next.
Okay.
I did that, yeah.
So unless you need me, I'm gonna go to my next meeting.
No, you're done. Your services are well ready.
All right. Good to
Motion
see
to
you all.
dismiss?
Yes.
Motion to dismiss. Thanks.
All right. So you'll tweak the decision?
I will send
I'll
it
take
to
a
you,
quick look at
and,
it, yeah,
we'll hopefully get that wrapped up soon.
perfect. All
I
right.
mean, do you have time tomorrow to look at it, you think?
I will make time,
Maybe
send it
to
to me.
him. If it's ready
I'm
to
just
go,
thinking,
yeah.
Yeah.
cause Still River will be ready as well.
Right, I gotta do
and then-
that, oh, you can do them both at the same time.
Well, I was thinking, like, if you review it and get it back to me,
Yeah.
both of those back to me, then Gerard can come.
Right,
And sign it hopefully Thursday.
Anytime.
Okay, 'cause I have to get it in on
Should open
Thursday.
work or something. Only thing, if it's a Friday.
No, not a Friday, because we're closed, but
My
Thursday.
niece is graduating from UMass, so I'm thinking, and going up for their graduation, yeah.
So that's,
But
Might just be convenient to sign both of them.
yeah,
Yeah.
oh, totally, yeah. Okay,
Okay.
we'll do it.
All right.
Great, have a great
Bye.
night. Good seeing
Bye.
you. Take care, folks.
Bye, David. All right, so,
So I spoke to, not really knowing cost certifications, I had called Mass Housing for some assistance because they're often regulatory agencies on these projects and review these all the time. So I spoke to Jennifer Laurel, who's a CPA with them,
Yep.
and she's basically walked me through this cost certification. And the memo is basically my notes from that discussion. So what I thought I could do is we could just go through the bullet points real
Yeah.
quick.
right,
So number one, essentially, she had no concerns or didn't see any red flags regarding the cost certification, so that was reassuring. The CPA that provided the cost certification or prepared the cost certification is a pre-qualified CPA with DHCD, so that checks that off, that's part of their guidelines. The developer provided a developer's certificate, which is also required by the guidelines, so we can check that one off. The computed profit, in this case it's a loss, for sales is a negative $1,210,065, or a negative 9.66%, less than the 20% allowable profit. And then next line item, in accordance with section 4B1 of the DHCD Comprehensive Permit Guidelines, the acquisition value, which is the price that they paid for the property, should not exceed the sum of the as-is market value, which is the appraised value, and the carrying cost. So $990,000 is the appraised value. The carrying cost, I calculated from the cost certificate to cost certification to be $459, excuse me, geez. And then for a total of $1,752,459, which is less than the acquisition value,
or greater than
or
that.
the value that they paid for the land. So then the next one sort of goes into more detail about the carrying cost. So in accordance with section 4B1C1 of the guidelines, reasonable carrying cost should not exceed 20% of the as-is market value of the site or the appraised value. So the way that the guidelines read, they say the carrying cost should include property taxes, property insurance, interest payments on acquisition, etc. So if you look at their cost certification, again, the appraised value is $990,000 times 20%, so that carrying cost should really only be $198,000. They, for their carrying costs, they listed a little over $11,000 for insurance, $138,815 for property taxes, and then a whopping $612,554 for construction loan interest for that $700,000 total. Obviously, that $700,000 total is much more than the 20% of the appraised value. So talking with Mass Housing, she wasn't really concerned. So attached to the memorandum are printouts from a spreadsheet that they use when they review these cost certifications. They basically plug all the numbers in. And what she did was she zeroed out, let's say that he didn't claim any of this, and they just zero it out. She said even with that, he's still making less than the allowed 20%, so she wasn't concerned, even though that number was a very high number.
And at the end of the day, that 20% is the real,
That's
the
what
real
we're,
threshold,
what-
because if it was over
exactly.
20%, he's gotta kick it back to the town.
Exactly, and that's the whole reason for this cost
Right.
search. So that's why she's like, I don't really have a concern with
Right,
that.
right.
Even though that number is, you know,
It looks.
questionable. Let's see. So the next one, in accordance with section 4B5B1 of the regulations, percentage of commissions, advertising, and market unit sales should not exceed 6%. So the commission advertising amount was $220,000. And then the market unit sales, total was $10,203,461. That divided out ends up being 2.2%, so it's less than that 6%. So that can kind of get checked off the list. So next one, section 4B5B2 of the regulation, the maximum allowable fee, including lottery costs, should not be greater than $20,000 or 3% of the sum of the affordable unit sale price. So the affordable unit sale price, according to the cost cert, is a little over $1 million. 3% of that is $32,361. The commission and advertising for the affordable unit is $380,942, plus the lottery cost, which is $24,196, equals $405,138. So again, Mass Housing wasn't concerned because the same approach, she zeroed out the cost for those, and again, it's still significantly less than that 20%. And to be honest with you, even if you zeroed out most of these costs, it would still be less than 20%.
But do these costs, did they go to him? I mean, did he have his own commission, did he have someone selling the homes, like commissions, right? At one time, just as an example, like I think Mark Wagan, his wife was like, or maybe his sex, but at some point I thought the company was doing the lotteries and the commissions and things like that.
Yeah, they have to, in their cost cert, they have to identify the related parties, so to be honest with you, I didn't check for that.
Well, there's a thing now, you see we had this, the term about related party cost shouldn't exceed 14%, so this probably.
Yeah,
So it caught-
Okay, so then the next one, section 4B2C3 of the regulations, the builder's profit should not exceed 6% of the construction cost, the builder overhead should not exceed 2% of the construction cost, and then general requirements should not exceed 6% of the construction cost. These line items are considered the total related party cost. So the first one, building profit, $461,224 divided by the construction cost of $8,769,057 comes out to 5.26%, so that's less than the 6%. Builder's overhead, $153,742 divided by the construction cost of $8,769,057. Percentage-wise, it's 1.75%, so that's less than 2%. Next one, general requirements, that number was $461,224 divided by the construction cost. That percentage ended up being 5.26% again.
Must have
less
some
than
allocations
6%.
because their way they equal always round out to the 5.2%, but that's all right. At least it's less than their figures, so.
Yeah, so you can check that off. The next one, in accordance with section 4B2C3 of the regulations, the total of the related party cost should not exceed 14% of construction, which is what Gerard was just talking about. So the total of those three line items is $1,076,190. If you divide that by the construction cost again, The percentage is 12.27%, which is again less than the 14%, so that satisfies that requirement. In accordance with section 4B5A1 of the regulations, the developer overhead reflects the expenses of the applicant administering and managing the project during the permitting, financing, construction, marketing, and cost certification phases, and is not a component of the allowable developer fee profit. The developer overhead cost should be as follows. So the guidelines literally break out what the number will be for you. So for 5 to 20 units, the allowable developer overhead is $80,000 plus $2,000 per units from 21 through 100. There are 28 units here, so it'll be 80,000 plus 2,000 times an additional 8 units. So that works out to be $96,000. If you look at the coster, that's exactly what they have listed there. So that matches up. And then lastly, in accordance with section 4B5C of the regulation, soft costs should not exceed 28% of the residential construction costs. So the total soft costs were $1,688,518 divided by the residential construction cost, which was $8,463,303, and that worked out to be 8%, and 8% is significantly less than the 28, and those are all the requirements within the guidelines. So
Great job.
Yeah.
You could teach a math class now.
this was painful.
Yeah. But, and so at the end of the day, all the things that were required on the site that he's taken care of. Because that, one of the
The
reasons.
site requirements were done, we released the bond for all of that work
Right.
based on our site visit years back.
Right.
This was the only thing that was
Nothing's cropped up, no
pending.
one's complaining that,
No,
he has
it's-
something to get done, and this was a recall that it was just pending cost certification.
Exactly. And the fact that Mass Housing has reviewed this with me and felt very comfortable with
Yeah.
it gave
Mhm.
me
Mhm.
a level of comfort as well.
Right.
And when they check most of the boxes.
Mhm.
And at the end of the day, like I said, even if you zero out those costs, he's still not making the 20%,
Right,
so.
right. Mhm. So the only other thing is then just to motion to, well, if we have any questions about it or concerns, but I don't have any myself.
I wouldn't know what to ask.
Well, other than, I'm not concerned that there's some like fuzzy provable, they had the CPA firms, it's gone through the vetting process, so I'm not
Yeah.
concerned with what.
I mean, my only concern is that is the money all this money that's being paid out, is it going to other companies or associated with his, so it ends up, everything stays in the family. But we don't really have any reason to believe that, so.
Well, because they have to on that related party, because that would have to be
Right.
disclosed as related party transactions. They-
Right.
Again, they met, the amount that was allowed is less than, the percentage is less than that, 12 versus 16, whatever the 14. So again,
Yeah.
yes, a lot of it,
Even so,
they
it's
can
all
sort of
under.
move the shells around, but at the end of the
Yeah.
day, vetted that
Mhm.
it's still within the parameters. I'm
Mhm.
sure they go into these projects knowing they have to check off these
Yeah.
Yeah, and
boxes
it
at some
was,
point,
the actual regulatory agency for this project is Community Housing Corp.
Mhm.
And I actually, CHI, so they're the ones that actually get the cost certification, and they're truly the ones that approve it or question it or whatever, and then it goes through the town as well. So I spoke to Avi Glazer from that CHI, and he didn't have any concerns either, so.
Mhm. Yeah. So the bond that exists right now is $5,000?
I believe so. I wanted to confirm with the accountant, and I didn't get a chance to, so I guess in the motion, if you just wanna say, to release all remaining bond money, and that way I'm covered, because I think it's at 5,000, but in case it's like $1 or whatever.
Yeah. Mhm. Right.
Right, we can just be done with it.
Right.
Okay, make a motion pending our review of this tonight in a positive manner that we release the bond in the full amount of whatever's there and approve it.
Second?
Second by Kay, so we have a motion to release the remaining bond amount back to Sunset Ridge.
Sunset Ridge.
So all in favor?
Aye.
Okay.
Wonderful.
We release it. Release the bond.
Release it.
Release the hound. So is that everything that we have on our agenda tonight? Nothing has cropped up?
Not for tonight,
Yeah,
no.
okay.
I hope to at some point have time to get those, I'm still behind on meeting minutes.
Have you heard anything back from Still River at this point, or is that quiet?
That's been pretty quiet. I sent the decision to Gerard and town council last week,
Yeah.
and I think town council's just been so busy. They're gonna get it to me tomorrow. And
His
then-
comments.
His
Because
comments
I didn't have, I
tomorrow.
mean, it's pretty substantially similar to what we looked at before. I mean, it was
Yeah.
percolating, and then, I just had a question, sort of like a couple, was there something missing at work? I mean, but it may not be, it may be fine as it is, so, but.
You had you had a good question on the stormwater, and it was confusing the way I wrote it, so I'm gonna update that part of it, and
If there
beyond
was a
that.
specific area, I couldn't tell if it was like stone,
Yeah, it
But
was-
anyway, yeah, so.
I will update that and hopefully get that. I have to get it recorded with Pam on Thursday.
Yeah, so, but I'll be available, so just let me know, and I'll shoot over and sign it.
Okay, what time works best for you?
I'll ping you tomorrow, I'll let me know
Okay.
my work calendars, I don't
Okay.
have it in front of me, but I know there's some meeting in the morning at work, but,
Okay, yeah, the only meeting I have is at 9.
yeah.
We do site visits at Keys Farm, but other than that.
Okay. Get those buttoned up.
Okay.
All right,
Make a motion to adjourn?
all right. Who wants to second that one?
Second.
Second. All right, so a motion to adjourn, second by Andy, all in favor?
Aye.
All right, so